Morning, Century 21. Happy Monday, and thank you for taking the time to come on my brand new first time presenting this Zoominar on non-payment of rent and termination of tenancy. So we're going to learn some really good stuff today, and you'll be able to be somewhat pros by the end of this presentation. So for those of you who haven't already done so, head over to our social media, like us, follow us on Facebook and Instagram. If you ever come across any questions that you need clarity on, I'm the easiest to get a hold of via email at info@stonegatelegalservices.ca, and feel free to check out our website. So let's get started. At the end of the presentation, what we can do is we can do a Q&A, and I will send a copy of this presentation to Tina, and she can send it over to you guys, and you can refer back to it and use it as reference. So I won't bore you with an intro about myself. You guys already know me already. For the purpose of this presentation, everything that we discuss is for information only and not to be taken as legal advice. So let's get started. So our first slide, did your tenant pay the rent this month? And the reason why we're going to start off with this question is that I always get asked, when do you serve a notice for non-payment of rent? Well, rent is considered late if it is paid only the day after it's due. Okay, it's not considered late if, on the first at 5 o'clock, you check the mailbox or you check your email and you don't have the rent. Rent is only considered late the day after it's due. I never recommend that you wait days to start a process. And the reason why I don't recommend that you wait for days is because you're losing valuable time. So if your rent is not paid on the first, the process should be started on the second of the month. And this is where the notice for non-payment of rent should be served. Okay, and one thing to keep in mind moving forward through the presentation is that any legal notice, especially the N4, must be free from any errors, no matter how minor the error. And when I say that it has to be free from errors, I mean, if there's an error in your name, or if you forget the postal code, or you forget the unit number, or you miscalculate, these are all errors that can, make this notice defective and therefore invalid on the date of your hearing. So you want to make sure that the N4 is drafted to the T. What does the N4 look like? So the N4, for those of you who are not familiar with this notice, is actually called the Notice to Terminate Tenancy for Non-Payment of Rent. This is the screenshot. This is what it looks like. On the left side, this is the front page. And on the right side is a screenshot of the second page. We're going to dissect it a little bit, and I'm going to explain what needs to be drafted and how things should be drafted when you are drafting a notice for non-payment of rent. Now, for the purpose of this presentation and moving forward, only the legal representative or the landlord can draft and serve the N4 on behalf of the client, which is the landlord. Okay, so realtors, stay away from it. This presentation is so that you know how to guide your clients when the landlord says, hey, the tenant hasn't paid rent, what do I do? Okay, but you're not going to do this for them. Now, the N4 for non-payment of rent, when it's served to the tenant, notifies the tenant that they owe rent arrears, okay? And basically, they have two options. Option number one, they must pay the arrears in full in order to void the notice within 14 days. Or option number two is that they must move out of the rental unit within 14 days. Those are the two options that they have. In order to void it, they have to pay in full or they have to move out of the property. Parties to the notice. Whenever you're drafting or whenever your landlord is drafting a notice for non-payment of rent, when you're listing the tenants' names, include those tenants that are listed in the lease agreement. Don't leave one out, because if you leave one out, then again, your notice is defective. In case of those tenancies that no agreement exists, include the names of all of the tenants who have been paying the rent. Okay, if your tenant, for example, uses a nickname or uses a shortened name, like if it was, I don't know, Anne Marie, and they refer to her as Anne, you would write Anne Marie and in brackets Anne. Include both their legal names and any nicknames. If there is a joint tenancy, which means that if there are two or more tenants together on the agreement, you have to include all tenants. Okay, so not just one tenant. If, for example, it's a joint tenancy and each tenant sends you an e-transfer for half. So tenant A sends you $500 and tenant B sends you $500, but you only received the rent from tenant A, you're still going to have to include tenant A and B on the N4. The same applies with landlords, okay? If you have to include all of the landlords. If there's John Doe and Jane Doe, you have to list John Doe and Jane Doe, not one landlord, all landlords. Occupants are not required to be included on the N4 because occupants are often, elderly parents, children. These are people who are living with the tenants just for the purpose of occupying the rental unit. They're not, they don't pay the rent and they're not on the lease. Okay. It's very important for the address of the rental unit to be included in full, exactly the way it's stated on the lease. Okay. So for example, if it's 123 ABC Street, basement unit 1, then you have to include 123 ABC Street, basement unit 1. You cannot just include 123 ABC Street. You have to be very specific because whoever is going to be serving the notice must also show that the notice was served to the right address. Like all notices at the Landlord and Tenant Board, the N4 notice to terminate tenancy for non-payment of rent has a termination date, okay? And what that termination date says, the termination date is a 14-day termination notice, and it gives the tenant 3 options. So option number 1, the tenant can pay the amount in full and void the notice by the 14th day. Option number 2, they must move out of the unit. And option number 3 is they can ignore it, do nothing, and wait for the landlord to file with the Landlord and Tenant Board, okay? So again, they either pay in full or they move out or they do nothing. If they do nothing, then the landlord has to start proceeding through the board in order to obtain a hearing date and start the eviction process. So we've talked about the contents of the first page of the N4. We're going to move on to the contents of the second page. This is where majority of errors occur. Okay, on the second page, this table in particular, where you have to put in the rent period, the rent charged, rent paid, and rent owing. This section must be filled out correctly. Again, any minor errors, and you're going to have to restart the process. Now, the most common error on the second page is where the rent period is, and that's the left side of it. See where it says rent period from and to? Well, if the rent starts on the 1st of the month, if rent is due and payable on the 1st, then the rent period is from the 1st to the 30th or 31st, okay? If the rent starts in the middle of the month on the 15th, then the rent period is from the 15th to the 14th. Okay, I always recommend that you prorate your rent so that the rent starts on the 1st for this purpose, so that the errors are, you don't make as many errors when the rent is due on the 1st. However, again, often when I'm reviewing leases, I see the leases for 1-year lease from the 1st to the 1st, and that's not a correct rent period. It's either from the 1st to the end of the month, from the 15th to the 14th, from the 5th to the 4th, however which way you have it in your lease. You just have to be mindful of it so that when you include it on the rent period on the N4, that it's done correctly. So signatures. Realtors and property managers cannot serve and enforce on behalf of their clients. I want to make that very, very clear. The board is not very realtor friendly, and they're not very property manager friendly. And I'm telling you this because, again, my background is in real estate and property management, and I've been to the board as a realtor and a property manager on behalf of my landlord clients. And often when they know that it's served by a realtor or a property manager, they dismiss the application and you have to start the process all over again. So who can serve the N4? As I mentioned, only the landlord or their legal representative can sign and serve the N4, unless the realtor is the landlord, okay? If there are multiple landlords, only one of them needs to sign the N4. There doesn't need to be multiple signatures. The date next to the signature is the date that the notice will be sent to the tenant. Okay. If there are multiple tenants, if there's tenant A, tenant B, tenant C, you must make a photocopy of the N4 and you must serve all three tenants. And again, anything that you serve or your the landlord or the legal rep serves, you must keep a copy for your records. It's very important that you do that. So what else do you need to know about the N4? Again, besides the fact that I'm going to be saying realtors and property managers cannot serve N4s on behalf of their clients. Only rent arrears can be listed on the N4. Okay, anything else listed will deem the notice as being a defective notice. So from my experience, I get a lot of landlords calling me saying, well, they haven't paid the rent and they haven't paid the utilities. Now, you cannot claim unpaid utilities on the N4. Okay, if you've already served your tenant with an N4 notice, and let's say, for example, you serve them on the termination date is April 17th or April 18th, you don't need to serve another one for the following month because the dates will actually take over middle of the following month. And you would have to update your rent arrears application when you go to the board. So you don't need to serve multiple N4s and only file one. Only one is sufficient enough to serve, okay? So once you have your N4 ready, your landlord has your N4 ready or their legal rep, how do you serve the tenants? Okay, this is really important. One thing I love about the real estate industry is that you guys have evolved with technology. And what I mean is that you're using your cell phones, you're scanning, you're sending documents, PDF, Facebook Messenger, WhatsApp, WeChat, you're using DocuSign to sign documents. However, I'll tell you, the wheels of justice spin very, very slowly, and landlords must serve their tenants in accordance to the rules of procedure at the Landlord and Tenant Board by way of a certificate of service, which is like kind of like proof of service. You have to show to the board that the tenant was served properly. The landlord may serve their tenants in one of the following ways, okay? By handing the document to the tenant, by handing it to another adult in the rental unit, placing it in the tenant's mailbox or where mail is usually delivered, sliding the document under the door or through a mail slot, faxing it to the tenant's residence or place of business by way of courier, registered mail, or express post. If you're using a mail service, whether it's regular mail, registered mail, express post, courier, additional days must be added to the date of termination. So just be mindful of that. When do you file the N4 and certificate of service to the Landlord and Tenant Board? So you've served the tenant, you filled out your certificate of service, you took a photocopy of your N4. When do you file it with the board? Well, the N4 can be filed with the board by way of an L1 application, evict the tenant for non-payment of rent and to collect rent arrears that the tenant owes as early as the day after the termination date on the N4, okay? If the N4 is not filed within 30 days of the termination date, then the notice becomes void automatically. Okay, so once filed with the board will issue a file number and they will set a date for a hearing. Let's talk about now. You filed it with the board. When do you expect to get a hearing date? So pre-COVID, it took an average of about 4 to 5 months in order to obtain a hearing date. As you are all aware, on March 16th, the board shut down due to COVID. They reopened on August 1st. However, due to the extensive backlog and delays, I've updated this current delays at the board just a few days ago. The average time it took to receive a hearing was about 9 to 12 months. Now on an N4 application, and since they're working through the backlog, it'll take anywhere around the 5 or 6 months in order to get a hearing date. Okay, so again, the board is working efficiently through the backlog, which is great. However, they are still experiencing delays. So what does a notice of hearing look like? So this is what a notice of hearing looks like. So once you filed with the board, you wait for a notice of hearing. As of August 1st, the board is now conducting video and telephone hearings for landlord applications and more specifically N4L1s. So the left side is a screenshot. This is what a notice of video hearing looks like. So anyone can attend a video hearing, either as a party to the application or an observer. As long as you have the link, you can attend. Now, you must attend the hearing date. Whether you're a tenant or a landlord, you have to attend your hearing date. If you don't attend, or if you don't send a legal representative to attend on your behalf, your hearing will go on without you. It's not that the board will call your name, and if you're not there, they'll hold the matter down and give you another date. It doesn't work that way. Okay, the hearing will go on without you, and more than likely, and this is 99% chance that it will not be in your favor. Again, parties are encouraged to work together to put together a repayment plan for the arrears. So if your landlord has a mindset that they're going to go to a hearing and they're going to evict the tenant immediately, this is not a realistic thing to keep. This is not a realistic thing to have in your head before you attend a hearing date, because more than likely the board will put together a repayment plan, and they will give the tenant an opportunity to mess up again. Okay, so that's basically what's going to happen at a hearing. Let's talk about other issues or any issues that a tenant can raise on a non-payment of rent hearing, because I go to the board on a lot of these applications to defend my landlords, and I find out that there are other underlying factors as to the reasons why the tenant is not paying the rent. And these are called Section 82 issues. And Section 82 is part of the Residential Tenancies Act. And what it allows the tenant to do is it allows the tenant to raise any issues that the tenant has because of as a result of not paying the rent. Okay, so a tenant can raise other issues, and more than likely, the other issues pertain to, poor maintenance or maintenance concerns, or charges that the landlord has charged them illegally. If these issues are not serious, this can be viewed as a delay tactic. So this is something that a tenant usually or sometimes does in order to prolong getting evicted. So let's say you've had your hearing at the board, the tenant raised issues, you worked through those issues, the board issued an order. Now, remember, I'm laying it out for you. I'm making it look easy. It's not as easy as the way I'm setting it out for you. What I'm taking you through is through the steps, okay? So at the hearing, this can happen. When an order is issued, this is what an order looks like, okay? So on the left is what an order looks like. The original copy of an order can be filed with the enforcement office or the sheriff's office in order to book a date for an eviction, okay? The order contains a date that the landlord has to proceed in order to proceed to book an eviction, because it also tells the tenant, you have to pay the rent moving forward. If the rent is not paid in full, or if the arrears are not paid in full by such and such date, then the day after, the landlord can enforce such order with the sheriff's office. Okay? Again, this is what you have to keep in mind, that evictions are not always the goal. It's not always cut and dry, because tenants can bring what we call a motion to set aside an order. And they can do this within 10 days that the board issues such an order, in order to put a hold or a stay on the order for another hearing to be held. So sometimes what tenants do is they bring a motion because they've paid the arrears to the landlord, and the landlord has gone ahead and filed with the enforcement office in order to evict them. And they want to prove to the board that, hey, I've paid my rent. Why is the landlord proceeding to evict me? Or on the flip side, if the tenant doesn't pay, they feel that they should be entitled to carry forward their tenancy, they will still file a motion to set aside the order. Again, this is another delay tactic. So now that we have the order, what happens at an eviction? Okay, so at an eviction, on the date of the eviction, the sheriff arrives. Now the sheriff's, this is a photocopy of a picture of the back of the sheriff's shirt, it says enforcement officer. The sheriff, they're not police officers. They're the only ones who can enforce an eviction. Okay. So on the date of the eviction, usually it's two sheriffs. They arrive to evict the tenant and they post a notice of vacant possession, which is what I've taken a screenshot of one of the notice of vacant possession, what it looks like to the right. They post this to the door, and this basically tells the tenant and anyone who has access to the unit that vacant possession is now given to the landlord and the locks have been changed. This means that the tenant is no longer allowed to reside in the property. Now, unless the landlord makes a side deal, which I don't know why they would do that and let the tenant back in, once they're evicted, they're evicted. This is it. This is the end of the road. But what happens now? Obviously, if the sheriff will knock on the door and tell the tenant, you have 15, 20 minutes to grab your belongings and you have to move out. Obviously, the tenant has bigger furniture. So what happens after the eviction? Well, I call it the 72-hour rule. And within 72 hours from the time that the tenant is evicted, the landlord must provide the tenant access to the property, obviously with a mutual agreed between such and such hours and mutually agreed upon time for the tenant to remove their belongings. I never recommend that the landlord say, here's a key, Mr. Tenant. You have 1 day or you have 5 hours to move your stuff out. Never, ever, ever give the tenant a key. Always make sure that you are there to either open the door and supervise, or you have someone open the door and supervise. Never give the key to the tenant. After the 72 hours, the landlord can do whatever he or she wants with whatever is left behind. They can dispose, sell, or keep anything. Now, once the tenant has been physically moved out of the property, their stuff is gone, how do you collect arrears? So this is what, a lot of landlords say to me is, now we've kicked out the tenant, I have an order for the collection of arrears. How can I enforce the collection of arrears? Well, by way of garnishment. Okay, so either garnishing the wages if the tenant is working, or by way of garnishing their bank account if you have their banking information. And this is, again, done through the small claims court. The paralegal will enforce garnishment of their wages. Okay, so we've come to the end of the presentation. Many of you have already downloaded our Landlord Mastery Guide. We've updated it. It gives you access to our Google Drive account. And again, I will send a copy of this presentation to Tina, and you can keep it as reference. But that is basically the non-payment of rent process. That takes you from when the tenant doesn't pay the rent to when they receive a notice of hearing, when they get an order, how to enforce the order by way of an eviction. Again, I've outlined it to make it look easy. It's for those of you who've actually been through a non-payment of rent matter that leads to an eviction. It is not as easy. It is actually a very, very stressful procedure. And I never recommend that anyone undertakes it and does it themselves, because one little minor mistake or error can throw you back.
Thank you so much for watching. If you like our video, please hit the like button, the subscribe, and even the little bell to get notifications, just so you can stay in touch and watch more of these great videos.